Sad day
What?
here for the American history.
This is the grand room. I was wondering whether this room was created.
You know now.
The House Committee on the Judiciary will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time.
Mr. Chairman,
Quorum.
you're reserving the right to object.
Objection is noted.
I reserve the right to object.
Gentleman is reserved.
Mr. Chairman, pursuant to Clause 2J1 of Rule 11, I am furnishing you with a demand for minority day of hearings on this subject, signed by all of the Republican
members. The gentleman will
members.
suspend. I could not understand what you were saying. Just repeat it more clearly.
Pursuant to Clause 2J1 of Rule 11, I am furnishing you with a demand for minority day of hearings on this subject, signed by all of the Republican members of the committee, and I would request that you set this date before the committee votes on any articles of impeachment.
It's a motion.
I withdraw my reservation.
We will confer and rule on this later. A quorum is present. This is the first hearing. This is the first hearing we are conducting pursuant to House Resolution 660 and the Special Judiciary Committee procedures that are described in Section 4A of that resolution. Here is how the committee will proceed for this hearing. I will make an opening statement, and then I will recognize the ranking member for an opening statement. Each witness will have 10 minutes to make their statements, and then we will proceed to questions. I will now recognize myself for an opening statement.
Mr. Chairman, parliamentary inquiry.
I have the time for an opening statement. The parliamentary inquiry is not in order at this time. The facts before us are undisputed. On July 25th, President Trump called President Zelensky of Ukraine, and in President Trump's words, asked him for a favor. That call was part of a concerted effort by the president and his men to solicit a personal advantage in the next election, this time in the form of an investigation of his political adversaries by a foreign government. To obtain that private political advantage, President Trump withheld both an official White House meeting from the newly elected president of a fragile democracy and withheld vital military aid from a vulnerable ally. When Congress found out about this scheme and began to investigate, President Trump took extraordinary and unprecedented steps to cover up his efforts and to withhold evidence from the investigators. And when witnesses disobeyed him, when career professionals came forward and told us the truth, he attacked them viciously, calling them traitors and liars, promising that they will, quote, go through some things, close quote. Of course, this is not the first time that President Trump has engaged in this pattern of conduct. In 2016, the Russian government engaged in a sweeping and systematic campaign of interference in our elections. In the words of Special Counsel Robert Mueller, quote, the Russian government perceived it would benefit from a Trump presidency and worked to secure that outcome, close quote. The president welcomed that interference. We saw this in real time when President Trump asked Russia to hack his political opponent. The very next day, a Russian military intelligence unit attempted to hack that political opponent. When his own Justice Department tried to uncover the extent to which a foreign government had broken our laws, President Trump took extraordinary and unprecedented steps to obstruct the investigation, including ignoring subpoenas, ordering the creation of false records, and publicly attacking and intimidating witnesses. Then as now, this administration's level of obstruction is without precedent. No other president has vowed to, quote, fight all of the subpoenas, unquote, as President Trump promised. In the 1974 impeachment proceedings, President Nixon produced dozens of recordings. In 1998, President Clinton physically gave his blood. President Trump, by contrast, has refused to produce a single document and directed every witness not to testify. Those are the facts before us. The impeachment inquiry has moved back to the House Judiciary Committee. And as we begin a review of these facts, the president's pattern of behavior becomes clear. President Trump welcomed foreign interference in the 2016 election. He demanded it for the 2020 election. In both cases, he got caught. And in both cases, he did everything in his power to prevent the American people from learning the truth about his conduct. On July 24th, the special counsel testified before this committee. He implored us to see the nature of the threat to our country. Quote, "Over the course of my career, I have seen a number of challenges to our democracy. The Russian government's effort to interfere in our elections is among the most serious. This deserves the attention of every American." Close quote. Ignoring that warning, President Trump called the Ukrainian president the very next day to ask him to investigate the president's political opponent. As we exercise our responsibility to determine whether this pattern of behavior constitutes an impeachable offense, it is important to place President Trump's conduct into historical context. Since the founding of our country, the House of Representatives has impeached only 2 presidents. A third was on his way to impeachment when he resigned. This committee has voted to impeach 2 presidents for obstructing justice. We have voted to impeach 1 president for obstructing a congressional investigation. To the extent that President Trump's conduct fits these categories, there is precedent for recommending impeachment here. But never before in the history of the Republic have we been forced to consider the conduct of a president who appears to have solicited personal political favors from a foreign government.
Never.
Never before has a president engaged in a course of conduct that included all of the acts that most concerned the framers.
Never.
The patriots who founded our country were not fearful men. They fought a war. They witnessed terrible violence. They overthrew a king. But as they met to frame our Constitution, those patriots still feared one threat above all: foreign interference in our elections. They had just deposed a tyrant. They were deeply worried that we would lose our newfound liberty, not through a war. If a foreign army were to invade, we would see that coming, but through corruption from within.
From within.
And in the early years of the Republic, they asked us, each of us, to be vigilant to that threat. Washington warned us, quote, "to be constantly awake, since history and experience prove that foreign influence is one of the most baneful foes of Republican government." Adams wrote to Jefferson, quote, "As often as elections happen, the danger of foreign influence recurs." Hamilton's warning was more specific and more dire. In the Federalist Papers, he wrote that the, quote, "most deadly adversaries of Republican government," unquote, would almost certainly attempt to, quote, "raise a creature of their own to the chief magistracy of the Union." In short, the founders warned us that we should expect our foreign adversaries to target our elections, and that we will find ourselves in grave danger if the president willingly opens the door to their influence. What kind of president would do that? How will we know if the president has betrayed his country in this manner? How will we know if he has betrayed his country in this manner for petty personal gain? Hamilton had a response for that as well. He wrote, "When a man unprincipled in private life, desperate in his fortune, bold in his temper, possessed of considerable talents, known to have scoffed in private at the principles of liberty, when such a man is seen to mount the hobby horse of popularity, to join the cry of danger to liberty, to take every opportunity of embarrassing the general government and bringing it under suspicion, it may justly be suspected that his object is to throw things into confusion, that he may ride the storm and direct the whirlwind." Ladies and gentlemen, the storm in which we find ourselves today was set in motion by President Trump. I do not wish this moment on the country. It is not a pleasant task that we undertake today, but we have each taken an oath to protect the Constitution, and the facts before us are clear. President Trump did not merely seek to benefit from foreign interference in our elections. He directly and explicitly invited foreign interference in our elections. He used the powers of his office to try to make it happen. He sent his agents to make clear that this is what he wanted and demanded. He was willing to compromise our security and his office for personal political gain. It does not matter that President Trump got caught and ultimately released the funds that Ukraine so desperately needed. It matters that he enlisted a foreign government to intervene in our elections in the first place. It does not matter that President Trump felt that these investigations were unfair to him. It matters that he used his office not merely to defend himself, but to obstruct investigators at every turn. We are all aware that the next election is looming, but we cannot wait for the election to address the present crisis. The integrity of that election is one of the very things at stake. The president has shown us his pattern of conduct. If we do not act to hold him in check now, President Trump will almost certainly try again to solicit interference in the election for his personal political gain. Today, we will begin our conversation where we should, with the text of the Constitution. We are empowered to recommend the impeachment of President Trump to the House if we find that he has committed treason, bribery, or other high crimes and misdemeanors. Our witness panel will help us to guide that conversation. In a few days, we will reconvene and hear from the committees that worked to uncover the facts before us. And when we apply the Constitution to those facts, if it is true that President Trump has committed an impeachable offense or multiple impeachable offenses, then we must move swiftly to do our duty and charge him accordingly. I thank the witnesses for being here today. I now recognize the ranking member of the Judiciary Committee,
Mr. Chairman.
the gentleman from Georgia, Mr. Collins,
Mr.
for his opening statement.
Mr. Chairman, may I make a parliamentary inquiry before you?
The gentleman is not in order for parliamentary inquiry. I've recognized the ranking member for an opening statement.
You're not in order.
I thank the chairman. And it is interesting that, again, parliamentary inquiries, and I believe some are actually some of the things I'm going to discuss today because we're sort of coming here today in a different arena. For everybody who's not been here before, this is a new room, it's new rules, it's a new month. We've even got cute little stickers for our staff so we can come in because we want to make this important. And this is impeachment because we've done such a terrible job of it in this committee before. But what's not new is basically what's just been reiterated by the chairman. What's not new is the facts. What's not new is it's the same sad story. What's interesting, even before I get into my part of my opening statement, is this what was just said by the chairman. We went back to a redo of Mr. Mueller. We're also saying, quoting him, saying the attention of the American people should be on foreign interference. I agree with him completely, except I guess the American people did not include the Judiciary Committee because we didn't take it up. We didn't have hearings. We didn't do anything to delve deeply into this issue. We passed election bills, but did not get into the in-depth part of what Mr. Mueller talked about, taking his own report and having hearings about that. We didn't do it. So I guess the American people doesn't include the House Judiciary Committee. You know, we also just heard an interesting discussion. We're going to have a lot of interesting discussion today about the Constitution and other things, but we also talked about the founders. What's interesting is that the chairman talked a lot about the founders from the quotes, and again, this is why we have the hearing, about the founders being concerned about foreign influence, but what he also didn't quote was the founders being really, really concerned about political impeachment. Because you just don't like the guy. You haven't liked him since November of 2016. The chairman has talked about impeachment since last year when he was elected chairman, 2 years ago, November 6th, 17th, before he's even sworn in as chairman. So don't tell me this is about new evidence and new things and new stuff. We may have a new hearing room, we may have new mics, and we may have chairs that aren't comfortable, but this is nothing new, folks. This is sad. So what do we have here today? You know what I'm thinking? I looked at this, and what is interesting is there's two things that have become very clear. This impeachment is not really about facts. If it was, I believe the other committees would have sent over recommendations for impeachment. Now they're putting it on this committee because if it goes badly, I guess they want to blame Adam Schiff's committee and his and others want to blame this committee for it going bad. But they're already drafting articles. Don't be fooled. They're already getting ready for this. We've already went after this with the Ukraine after numerous failings of Mueller, Cohen, annulments. The list goes on. But the American people are actually failing to see us legislate. But if you want to know what's really driving this, there's two things. It's called the clock and the calendar. The clock and the calendar. Most people in life, if you want to know what they truly value, you look at their checkbook and their calendar. You know what they value. That's what this committee values. Time. They want to do it before the end of the year. Why? Because the chairman said it just a second ago. Because we're scared of the elections next year. We're scared of the elections that we'll lose again. So we got to do this now. The clock and the calendar are what's driving impeachment, not the facts. When we understand this, that's what the witnesses here will say today. What do we have here today? What is really interesting over today and for the next few weeks?
He wasn't explicitly talking about doing this year because of necessarily what you're talking about. What he was referring to was the fact that we do not want to see the same occurrences that happened in the last election that's coming up in this election. So in order to head it off, stop it, pertaining to it occurring again, is the reason why that he decided to put such of a urgency on getting this done this year. Apparently, you haven't read the transcripts, and apparently you haven't interpreted the urgency of all this pertaining to our democracy possibly being corrupted all the way down to its very, very fundamental core pertaining to the axis of all this. Whenever you get to looking at the hub of our founders, the very thing that they was concerned about was what the chairman talked about a while ago, was the corruption coming from within. From within. Not a Pearl Harbor calamity, because if a Pearl Harbor calamity was coming our way, we would see it. Or they claimed that they would. I don't know. They didn't see 9/11 until after 9/11 occurred. But this is something that is going on within the branches of the government. And that's the reason why it is imperative that we understand and realize what the primary motives in behind our chief and commander was to begin with. And I have said all along, and I'll say again, Donald Trump may have had a valid reason towards doing this based upon the knowledge that he knew about that happened during the Obama era in how different things was mishandled, misfortunately, with the Ukrainian government. I don't know. I haven't heard all the evidence yet, and I'm still leaving it on the table. But the fact of the matter is, Donald Trump did, in fact, hold back military aid from our ally, a person that Congress had already said, we have your backs. We're with you on this. And Donald Trump held up that aid for a certain amount of days until after he figured out that he had been busted. He had been caught. After he realized that he had been caught, within a 48-hour period, he released the aid. That in and of itself is supposed to require Congress in doing so a vote. And Donald Trump took it upon himself towards doing that. Now we have to find out why he done that. We know he done that. Now the next $64,000 question is, why did you do that? And was it primarily just to better yourselves in a petty campaign coming up? Or was you doing it because there was some other bigger picture beyond that picture that we didn't understand or realize? That's what these hearings is all in conjunction to.
Is America will see why most people don't go to law school. No offense to our professors. But please, really, we're bringing you in here today to testify on stuff that most of you have already written about, all four, for the opinions that we already know, out of the classrooms that maybe you're getting ready for finals in, to discuss things that you probably haven't even had a chance to, unless you're really good on TV and watching the hearings for the last couple of weeks, you couldn't have possibly actually digested the Adam Schiff report from yesterday or the Republican response in any real way. Now, we can be theoretical all we want, but the American people is really going to look at this and say, huh? What are we doing? Because there's no fact witnesses planned for this committee. That's an interesting thing. Frankly, there's no plan at all except next week an ambiguous hearing on the presentation from the HIPC, the other committee that sent us the report, and Judiciary Committee, which I'm not still sure what they want us to present on, and nothing else. No plan. I asked the chairman before we left for Thanksgiving to stay in touch. Let's talk about what we have because history will shine a bright light on us starting this morning. Crickets. Until I asked for a witness the other day, and let's just say that didn't go well. There's no whistleblower. And by the way, it was proved today that he's not or she's not afforded the protection of identity. It's not in the statute. It's just something that was discussed by Adam Schiff. We also don't have Adam Schiff, who wrote the report. He said yesterday in a press conference, I'm not going to. I'll send staff to do that. He's not going to, but to me, if he was wanting to, he'd come begging to us. But here's the problem. It sums it up very simply like this. Just 19 minutes after noon on Inauguration Day 2017, the Washington Post ran the headline, "The campaign to impeach the president has begun." Mark Zadd, who would later become the attorney for the infamous whistleblower, tweeted in January 2017, "The coup has started. The impeachment will follow ultimately." And in May of this year, Al Green says, if we don't impeach the president, he'll get re-elected. If you want to know what's happening, here we go. Why did everything that I say up to this point about no fact witnesses, nothing for the Judiciary Committee, which spent 2.5 weeks before this hearing was even held under Clinton? 2.5 weeks. We didn't even find your names out until less than 48 hours ago. I don't know what we're playing hide the ball on. It's pretty easy what you're going to say. But we can't even get that straight. So what are we doing for the next 2 weeks? I have no idea. The chairman just said an ambiguous hearing on the report, but nothing else. If we're going to simply not have fact witnesses, when we are the rubber stamp hiding out back, the very rubber stamp the chairman talked about 20 years ago. What a disgrace to this committee. To have the committee of impeachment simply take from other entities and rubber stamp it. You see, why do the things that I say matter about fact witnesses and actually hearing and actually having this a due process? Because, by the way, just a couple of months ago, the Democrats got all sort of dressed up, if you would, and says, we're going to have due process protection for the president and good fairness throughout this. This is the only committee in which the president would even have a possibility. But no offense to you, the law professors. The president has nothing to ask you. You're not going to provide anything he can't read. And his attorneys have nothing else. Put witnesses in here that they can be fact witnesses who can be actually cross-examined. That's fairness, and every attorney on this panel knows that. This is a sham. But what I also see here is quotes like this. There must never be a narrowly voted impeachment or an impeachment supported by one of our major political parties or imposed by another. Such an impeachment will produce divisiveness, bitterness in politics for years to come, and will call into question the very legitimacy of our political institutions. The American people are watching. They will not forget. You have the votes. You may have the muscle, but you do not have the legitimacy of a national consensus or of a constitutional imperative. The partisan coup d'etat will go down in infamy in the history of the nation. How about this one? I think the key point is that the Republicans are still running a railroad job with no attempt at fair procedure. And today, when the Democrats offered amendments, offered motions in committee to say we should first discuss and adopt standards so that we know we're dealing with, standards for impeachment that was voted down or ruled out of order. When we say the important thing is to start looking at the question before we simply have a vote with no real inquiry first, that was voted down and ruled out of order. So frankly, the whole question of what material should be released and what is secondary, but that's all we discussed. The essential question, and here it is, which is to set up a fair process as to whether the country put this country through an impeachment proceeding. That was ruled out of order. The Republicans refused to let us discuss it. Those are all Chairman Nadler before he was chairman. I guess 20 years makes a difference. This is an interesting time. We're having a factless impeachment. You just heard a one-sided presentation of facts about this president. Today we will present the other side, which gets so conveniently left out. Remember, fairness does dictate that, but maybe not here, because we're not scheduling anything else. I have a Democratic majority who has poll tested what they think they ought to call what the president they think he did. Wow, that's not following the facts. We have just a deep-seated hatred of a man who came to the White House and did what he said he was going to do. The most amazing question I got in the first 3 months of this gentleman's presidency from reporters was this: can you believe he's putting forward those ideas? I said, yes, he ran on them. He told the truth, and he did what he said. The problem here today is this will also be one of the first impeachments. The chairman mentioned there was two of them, one that before he resigned before, and then one in Clinton, in which the facts, even by Democrats and Republicans, were not really disputed. In this one, they're not only disputed, they're contradicted of each other. There are no set facts here. In fact, they're not anything that presents an impeachment here, except a president carrying out his job in the way the Constitution saw that he sees fit to do it. This is where we're at today. So the interesting thing that I come to with most everybody here is this may be a new time, a new place, and we may be all scrubbed up and looking pretty for impeachment. But this is not an impeachment. This is just a simple railroad job. And today's is a waste of time, because this is where we're at. So
a backwoods hearing? Is that what he just accused the people up in Washington towards conducting? Whenever you take taxpayer dollars and you buy out all these TV stations, TV programs, so that this can be conducted live? Is that what he just said? That this is a backwoods? I'm without words in what he's saying.
Close today with this. It didn't start with Mueller. It didn't start with a phone call. You know where this started?
Yeah, it started 30 years ago, of the corruption of various people that has led us down a winding road that has led us to where we are right now. Now that I do agree with what Donald Trump talked about. And because the chips is on the table and the stakes is high, this is what we're getting towards what didn't happen that should have happened in 1988. Yeah, people like myself can see through this. We know where all this was generated from.
Started with tears in Brooklyn in November 2016 when an election was lost. So we are here, no plan, no fact witnesses, simply being a rubber.
Let's back up. Right there.
Because this is where we're at. So I close today with this. It didn't start with Mueller. It didn't start with a phone call. You know where this started? It started with tears in Brooklyn in November 2016 when an election was lost. So we are here, no plan, no fact witnesses, simply being a rubber stamp for what we have. But hey, we got law professors here. What a start of a party. Mr. Chairman, before I yield back, I have a motion under Clause 2, Rule 11.
The gentleman was recognized for the purpose of an opening statement, not for the purpose of making a motion.
I yield back and now ask for recognition for a motion under Clause 2, Rule 11.
The gentleman is recognized.
Mr. Chairman, pursuant to Clause 2 of Rule 11, I move to require the attendance and testimony of Chairman Schiff before this committee and transmit this letter accordingly.
For what purpose does the gentlelady seek recognition?
Move to table the motion.
Motion to table is made and not debatable. All in favor of the motion to table say aye. Aye. Opposed?
No.
The motion to table is agreed to.
Recorded vote.
The recorded vote is requested. The clerk will call the roll.
Parliamentary inquiry, Mr. Chairman.
The clerk will call the roll.
Parliamentary inquiry, Mr. Chairman.
You're not recognized for parliamentary inquiry at this time. There's a vote in process.
Just a reminder, any no votes that you don't want chairmanship coming,
You're
correct?
not recognized.
The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Johnson of Georgia votes aye. Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Mr. Richmond? Mr. Richmond votes yes. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
Yes.
Mr. Swalwell votes yes. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa?
Aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath?
Aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel Powell?
Aye.
Ms. Mucarsel Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins?
No.
Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler?
No.
Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong?
No.
Mr. Armstrong votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no.
Has everyone voted who wishes to vote?
Ms. Bass?
Ms. Bass?
Ms. Bass votes aye.
The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The motion to table is agreed to.
Mr. Chairman, I have a parliamentary inquiry.
The gentleman will state his parliamentary inquiry.
Thank you, Mr. Chairman. Clause C2 of the Judiciary Committee's impeachment inquiry procedures states that members of the committee can raise objections relating to the admissibility of testimony and evidence, but it doesn't say what rules apply to admissibility. So I'm hoping you can explain to us what the objections may be made under this clause, and if you intend to use the federal rules of evidence.
The gentleman will suspend. That is not a proper parliamentary inquiry.
It is a proper.
It is not a proper parliamentary.
I stated a rule. I stated
a rule, Mr. Chairman. You can ignore it and not answer it, but you can't just say it's not a proper.
I'm asking for the application of the rule for an explanation, Mr.
We
Chairman.
will
I don't know how
apply.
that's not parliamentary.
We will apply the rules. Period.
You won't help us understand that? There's no clarity there.
Which rule are
as I
you
said.
citing? How are you citing that?
Clause C2 of the Judiciary Committee's impeachment inquiry procedures. How's that unclear?
It's the rules of the House, and they will be applied. Period. That's the reply.
I'm asking how will they be applied here, sir?
They will be applied according to the rules.
But not answering your question.
A circular response. Thank you. And Mr. Chairman, can you please also iterate the schedule going forward? In other words, are you planning to hold additional hearings? And if so, when do you
The gentleman will
anticipate
suspend.
releasing or?
That is not a proper parliamentary inquiry. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses.
Mr. Chairman.
Noah Feldman.
Mr. Chairman.
Felix.
Chairman, I seek recognition.
The gentleman is. I am not going to recognize you now. I am introducing the witnesses.
Mr. Chairman,
Noah Feldman is the Felix Frankfurter Professor of Law at Harvard Law School. Professor Feldman has authored 7 books, including a biography of James Madison and a constitutional law casebook, as well as many essays and articles on constitutional subjects. Professor Feldman received his undergraduate degree from Harvard College, a doctor of philosophy from Oxford University, where he was also a Rhodes Scholar, and a JD from Yale Law School. He also served as a law clerk to Justice David Souter of the United States Supreme Court. Pamela Carlin serves as the Kenneth and Harl Montgomery Professor of Public Interest Law and the co-director of the Supreme Court Litigation Clinic at Stanford Law School. She is the co-author of several leading case books, including a monograph entitled Keeping Faith with the Constitution and dozens of scholarly articles. She served as a law clerk to Justice Harry Blackburn of the United States Supreme Court and as a Deputy Assistant Attorney General in the Civil Rights Division of the United States Department of Justice, where she was responsible, among other things, for reviewing the work of the department's voting section. Professor Carlin earned 3 degrees from Yale University, a BA in history, an MA in history, and a JD from Yale Law School. Michael Gerhardt is the Burton Craig Distinguished Professor of Jurisprudence at the University of North Carolina School of Law and Director of UNC's Center on Law and Government. Professor Gerhardt is the author of many books, including The Federal Impeachment Process, a Constitutional and Historical Analysis, as well as more than 50 law review publications on a diverse range of topics in constitutional law, federal jurisdiction, and the legislative process. He received his JD from the University of Chicago Law School, his MS from the London School of Economics, and his BA from Yale University. Jonathan Turley is the J.B. and Maurice C. Shapiro Chair of Public Interest Law at George Washington University Law School, where he teaches torts, criminal procedure, and constitutional law. After a stint at Tulane Law School, Professor Turley joined the GW Law faculty in 1990, and in 1998 became the youngest chaired professor in the school's history. He has written over 36 academic articles for a variety of leading law journals, and his articles on legal and policy issues appear frequently in national publications. A Chicago native, Professor Turley earned degrees from the University of Chicago and Northwestern University School of Law. We welcome all our distinguished witnesses. We thank them for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show the witnesses answered in the affirmative. Thank you, and please be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 10 minutes. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 10 minutes have expired. Professor Feldman, you may begin. I don't think you're on the mic.
Mr. Chairman, before we get...
Mr. Chairman and members of the committee.
Mr. Chairman, I have a motion.
The gentleman is not in order to offer a motion at this time.
Mr. Chairman, I seek recognition for a privilege motion.
Mr. Chairman and members of the committee, thank you very much for the opportunity to appear. My name is Noah Feldman. I serve as the
witness will proceed.
I serve as the Felix Frankfurter Professor of Law at the Harvard Law School.
I seek recognition
My
for
job
a privilege
is
motion.
to study.
The gentleman will suspend. The time is the witnesses.
The privilege motion needs to be recognized.
Privilege.
You can call it not a privilege.
In between the witnesses, it may be recognized. Not once I recognize the witness. So the witness will proceed. We'll entertain the motion after the first witness.
My job is to study and to teach the Constitution from its origins until the present. I'm here today to describe 3 things. Why the framers of our Constitution included a provision for the impeachment of the president. What that provision, providing for impeachment for high crimes and misdemeanors, means. And last, how it applies to the question before you and before the American people, whether President Trump has committed impeachable offenses under the Constitution. Let me begin by stating my conclusions. The framers provided for the impeachment of the president because they feared that the president might abuse the power of his office for personal benefit, to corrupt the electoral process and ensure his re-election, or to subvert the national security of the United States. High crimes and misdemeanors are abuses of power and of public trust connected to the office of the presidency. On the basis of the testimony and the evidence before the House, President Trump has committed impeachable high crimes and misdemeanors by corruptly abusing the office of the presidency. Specifically, President Trump has abused his office by corruptly soliciting President Volodymyr Zelensky of Ukraine to announce investigations of his political rivals in order to gain personal advantage, including in the 2020 presidential election. Let me begin now with the question of why the framers provided for impeachment in the first place. The framers borrowed the concept of impeachment from England, but with one enormous difference. The House of Commons and the House of Lords could use impeachment in order to limit the ministers of the king, but they could not impeach the king, and in that sense, the king was above the law. In stark contrast, the framers, from the very outset of the Constitutional Convention in 1787, made it crystal clear that the president would be subject to impeachment in order to demonstrate that the president was subordinate to the law. If you will, I would like you to think now about a specific date in the Constitutional Convention, July 20th, 1787. It was the middle of a long, hot summer, and on that day, two members of the Constitutional Convention actually moved to take out the impeachment provision from the draft Constitution. And they had a reason for that, and their reason was, they said, well, the president will have to stand for re-election. And if the president has to stand for re-election, that is enough. We don't need a separate provision for impeachment. When that proposal was made, significant disagreement ensued. The governor of North Carolina, a man called William Davie, immediately said, if the president cannot be impeached, quote, he will spare no efforts or means whatever to get himself re-elected. Following Davie, George Mason of Virginia, a fierce Republican critic of executive power, said no point is more important than that impeachment be included in the Constitution. Shall any man be above justice? He asked, thus expressing the core concern that the president must be subordinate to the law and not above the law. James Madison, the principal draftsman of the US Constitution, then spoke up. He said it was, quote, indispensable that some provision be made for impeachment. Why? Because, he explained, standing for re-election was, quote, not a sufficient security, close quote, against presidential misconduct or corruption. A president, he said, might betray his trust to foreign powers. A president who, in a corrupt fashion, abused the office of the presidency, said James Madison, quote, might be fatal to the republic, close quote. And then a remarkable thing happened in the convention. Gouverneur Morris of Pennsylvania, one of the two people who had introduced the motion to eliminate impeachment from the Constitution, got up and actually said the words, I was wrong. He told the other framers present that he had changed his mind on the basis of the debate on July 20th, and that it was now his opinion that in order to avoid corruption of the electoral process, a president would have to be subject to impeachment regardless of the availability of a further election. The upshot of this debate is that the framers kept impeachment in the Constitution specifically in order to protect against the abuse of office with the capacity to corrupt the electoral process or lead to personal gain. Now, turning to the language of the Constitution, the framers used the words high crimes and misdemeanors to describe those forms of action that they considered impeachable. These were not vague or abstract terms to the framers. High crimes and misdemeanors the words high crimes and misdemeanors represented very specific language that was well understood by the entire generation of the framers. Indeed, they were borrowed from an impeachment trial in England that was taking place as the framers were speaking, which was referred to, in fact, by George Mason. The words high crimes and misdemeanors refer to abuse of the office of the presidency for personal advantage, or to corrupt the electoral process, or to subvert the national security of the United States. There's no mystery about the words high crimes and misdemeanors. The word high modifies both crimes and misdemeanors, so they're both high. And high means connected to the office of the presidency, connected to office.
Right.
The classic form that was familiar to the framers was the abuse of office for personal gain or advantage. And when the framers specifically named bribery as a high crime and misdemeanor, they were naming one particular version of this abuse of office, the abuse of office for personal or individual gain. The other forms of abuse of office to affect elections, and abuse of office to compromise national security, were further forms that were familiar to the framers. Now, how does this language of high crimes and misdemeanors apply to President Trump's alleged conduct? Let me be clear. The Constitution gives the House of Representatives, that is, the members of this committee and the other members of the House, quote, sole power of impeachment. It's not my responsibility or my job to determine the credibility of the witnesses who appeared before the House thus far. That is your constitutional responsibility. My comments will therefore follow my role, which is to describe and apply the meaning of impeachable offenses to the facts described by the testimony and evidence before the House. President Trump's conduct, as described in the testimony and evidence, clearly constitutes impeachable high crimes and misdemeanors under the Constitution. In particular, the memorandum and other testimony relating to the July 25th, 2019 phone call between the two presidents, President Trump and President Zelensky, more than sufficiently indicates that President Trump abused his office by soliciting the president of Ukraine to investigate his political rivals in order to gain personal political advantage, including in relation to the 2020 election. Again, the words abuse of office are not mystical or magical. They are very clear. The abuse of office occurs when the president uses a feature of his power, the awesome power of his office, not to serve the interests of the American public, but to serve his personal, individual, partisan, electoral interests. That is what the evidence before the House indicates. Finally, let me be clear that on its own, soliciting the leader of a foreign government in order to announce investigations of political rivals and perform those investigations would constitute a high crime and misdemeanor. But the House also has evidence before it that the president committed two further acts that also qualify as high crimes and misdemeanors. In particular, the House heard evidence that the president placed a hold on critical U.S. aid to Ukraine and conditioned its release on announcement of the investigations of the Bidens and of the discredited CrowdStrike conspiracy theory. Furthermore, the House also heard evidence that the president conditioned a White House visit desperately sought by the Ukrainian president on announcement of the investigations. Both of these acts constitute impeachable high crimes and misdemeanors under the Constitution. They each encapsulate the framers' worry that the President of the United States would take any means whatever to ensure his re-election. And that is the reason that the framers provided for impeachment in a case like this one.
Mr. Chairman, I seek
Gentleman's time
recognition.
has expired.
Mr. Chairman, I seek recognition.
The gentleman is recognized.
I offer a motion to postpone to a date certain.
I move to table the motion.
Motion to table is heard and is not debatable. All in favor of the motion to table? All in favor of the
May
motion?
we have the motion read,
Not debatable.
please?
The motion was stated as to adjourn to its date.
May we have the motion read,
The
please?
motion will be read as to what date?
Motion to be read to a date certain, Wednesday, December 11th, 2019, so we can actually get a response to the 6
The
letters.
gentleman has stated his motion. Motion to table is made.
Correct.
Motion to table is made and not debatable. All in favor? The motion to table will say aye. Aye. Opposed?
No.
The motion to table is agreed to.
Roll call.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia?
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch?
Aye.
Mr. Deutsch votes aye. Ms. Bass?
Aye.
Ms. Bass votes aye. Mr. Richmond?
Yes.
Mr. Richmond votes yes. Mr. Jeffries?
Aye.
Mr. Jeffries votes aye. Mr. Cicilline?
Aye.
Mr. Cicilline votes aye. Mr. Swalwell?
Yes.
Mr. Swalwell votes yes. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal?
Aye.
Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Steen?
Aye.
Ms. Steen votes aye. Ms. McCarcel-Powell?
Aye.
Ms. McCarcel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Buck votes no. Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock?
No.
Mr. McClintock votes no. Ms. Lesko?
No.
Ms. Lesko votes no. Mr. Reschenthaler?
No.
Mr. Reschenthaler votes no. Mr. Klein?
No.
Mr. Klein votes no. Mr. Armstrong?
No.
Mr. Armstrong votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no.
Has everyone voted who wishes to vote? The clerk will report.
Mr. Chairman, there are 24 ayes and 17 noes.
The motion to table is adopted, and I now recognize Professor Carlin for her testimony.
Mr. Chairman and members of the committee, thank you so much for the opportunity to testify. Twice, I have had the privilege of representing this committee and its leadership in voting rights cases before the Supreme Court. Once when it was under the leadership of Chairman Sensenbrenner, and it's good to see you again, sir, and with Mr. Shabbat as one of my other clients, and once under the leadership of Chairman Conyers. It was a great honor for me to represent this committee because of this committee's key role over the past 50 years in ensuring that American citizens have the right to vote in free and fair elections. Today, you're being asked to consider whether protecting those elections requires impeaching a president. That is an awesome responsibility. That everything I know about our Constitution and its values, and my review of the evidentiary record, and here, Mr. Collins, I would like to say to you, sir, that I read transcripts of every one of the witnesses who appeared in the live hearing because I would not speak about these things without reviewing the facts. So I'm insulted by the suggestion that as a law professor, I don't care about those facts. But everything I read on those occasions tells me that when President Trump invited, indeed demanded foreign involvement in our upcoming election, he struck at the very heart of what makes this a republic to which we pledge allegiance. That demand, as Professor Feldman just explained, constituted an abuse of power. Indeed, as I want to explain in my testimony, drawing a foreign government into our elections is an especially serious abuse of power because it undermines democracy itself. Our Constitution begins with the words, "We the people," for a reason. Our government, in James Madison's words, derives all its powers directly or indirectly from the great body of the people. And the way it derives these powers is through elections. Elections matter, both to the legitimacy of our government and to all of our individual freedoms, because as the Supreme Court declared more than a century ago, voting is preservative of all rights. So it is hardly surprising that the Constitution is marbled with provisions governing elections and guaranteeing governmental accountability.
Exactly.
Indeed, a majority of the amendments to our Constitution since the Civil War have dealt with voting or with terms of office.
Right.
And among the most important provisions of our original Constitution is the guarantee of periodic elections for the presidency, one every 4 years. America has kept that promise for more than 2 centuries, and it has done so even during wartime. For example, we invented the idea of absentee voting so that Union troops who supported President Lincoln could stay in the field during the election of 1864.
Exactly.
And since then, countless other Americans have fought and died to protect our right to vote.
Right.
But the framers of our Constitution realized that elections alone could not guarantee that the United States would remain a republic. One of the key reasons for including the impeachment power was a risk that unscrupulous officials might try to rig the election process. Now, you've already heard 2 people give William Davey his props. Hamilton got a whole musical, and William Davey is just going to get this committee hearing. But he warned that unless the Constitution contained an impeachment provision, a president might spare no efforts or means whatsoever to get himself reelected. And George Mason insisted that a president who procured his appointment in the first instance through improper and corrupt acts should not escape punishment by repeating his guilt. And Mason was the person responsible for adding high crimes and misdemeanors to the list of impeachable offenses. So we know from that the list was designed to reach a president who acts to subvert an election, whether that election is the one that brought him into office or it's an upcoming election where he seeks an additional term.
Yes.
Moreover, the founding generation, like every generation of Americans since, was especially concerned to protect our government and our democratic process from outside interference. For example, John Adams, during the ratification, expressed concern with the very idea of having an elected president, writing to Thomas Jefferson that you are apprehensive of foreign interference, intrigue, influence. So am I. But as often as elections happen, the danger of foreign influence recurs. And in his farewell address, President Washington warned that history and experience prove that foreign influence is one of the most baneful foes of Republican government. And he explained that this was in part because foreign governments would try and foment disagreement among the American people and influence what we thought. The very idea that a president might seek the aid of a foreign government in his re-election campaign would have horrified them. But based on the evidentiary record, that is what President Trump has done. The list of impeachable offenses that the framers included in the Constitution shows that the essence of an impeachable offense is a president's decision to sacrifice the national interest for his own private ends. Treason, the first thing listed, lay in an individual's giving aid to a foreign enemy. That is, putting a foreign enemy's adversary's interests above the interests of the United States. Bribery occurred when an official solicited, received, or offered a personal favor or benefit to influence official action, risking that he would put his private welfare above the national interest. And high crimes and misdemeanors captured the other ways in which a high official might, as Justice Joseph Story explained, disregard public interests in the discharge of the duties of political office.
Duties.
Based on the evidentiary record before you, what has happened in the case today is something that I do not think we have ever seen before.
Ever.
A president who has doubled down on violating his oath to faithfully execute the laws and to protect and defend the Constitution. The evidence reveals a president who used the powers of his office to demand that a foreign government participate in undermining a competing candidate for the presidency. As President John Kennedy declared, the right to vote in a free American election is the most powerful and precious right in the world. But our elections become less free when they are distorted by foreign interference. What happened in 2016 was bad enough. There is widespread agreement that Russian operatives intervened to manipulate our political process. But that distortion is magnified if a sitting president abuses the powers of his office actually to invite foreign intervention. To see why, imagine living in a part of Louisiana or Texas that's prone to devastating hurricanes and flooding. What would you think if you lived there and your governor asked for a meeting with the president to discuss getting disaster aid that Congress has provided for? What would you think if that president said, I would like you to do us a favor. I'll meet with you and I'll send the disaster relief once you brand my opponent a criminal.
Right.
Wouldn't you know in your gut that such a president had abused his office?
Right.
That he betrayed the national interest and that he was trying to corrupt the electoral process? I believe that the evidentiary record shows wrongful acts on that scale here. It shows a president who delayed meeting a foreign leader and providing assistance that Congress and his own advisors agreed serves our national interest in promoting democracy and in limiting Russian aggression. Saying, Russia, if you're listening, a president who cared about the Constitution would say, Russia, if you're listening, butt out of our elections. And it shows a president who did this to strong-arm a foreign leader into smearing one of the president's opponents in our ongoing election season. That's not politics as usual, at least not in the United States or not in any mature democracy. It is instead a cardinal reason why the Constitution contains an impeachment power. Put simply, a president should resist foreign interference in our elections, not demand it and not welcome it. If we are to keep faith with our Constitution
Exactly.
and with our republic, President Trump must be held to account. Thank you.
Thank you, Professor Gerhardt.
Thank you, Mr. Chairman, ranking member,
Jesus.
other distinguished members of the committee. It's an honor and a privilege to join the other distinguished witnesses to discuss a matter of grave concern to our country and to our Constitution. Because this House, the People's House, has the sole power of impeachment, there is no better forum to discuss the constitutional standard for impeachment and whether that standard has been met in the case of the current President of the United States. As I explain in the remainder and balance of my opening statement, the record compiled thus far shows the President has committed several impeachable offenses, including bribery, abuse of power, and soliciting a personal favor from a foreign leader to benefit himself personally, obstructing justice, and obstructing Congress. Our hearing today should serve as a reminder of one of the fundamental principles that drove the founders of our Constitution to break from England and to draft their own Constitution. The principle that in this country, no one is king. We have followed that principle since before the founding of the Constitution, and it is recognized around the world as a fixed, inspiring American ideal. In his third message to Congress in 1903, President Theodore Roosevelt delivered one of the finest articulations of this principle. He said, "No one is above the law and no man is below, nor do we ask any man's permission when we require him to obey it. Obedience to the law is demanded as a right, not asked for as a favor." Three features of our Constitution protect the fundamental principle that no one, not even the President, is above the law. First, in the British system, the public had no choice over the monarch who ruled them. In our Constitution, the framers allowed elections to serve as a crucial means for ensuring presidential accountability. Second, in the British system, the king could do no wrong, and no other parts of the government could check his misconduct. In our Constitution, the framers developed the concept of separation of powers, which consists of checks and balances designed to prevent any branch, including the presidency, from becoming tyrannical. Third, in the British system, everyone but the king was impeachable. Our framers' generation pledged their lives and fortunes to rebel against a monarch whom they saw as corrupt, tyrannical, and entitled to do no wrong. In our Declaration of Independence, the framers set forth a series of impeachable offenses that the king had committed against the American colonists. When the framers later convened in Philadelphia to draft our Constitution, they were united around a simple, indisputable principle that was a major safeguard for the public, we the people, against tyranny of any kind.
Now I want to stop right there. He's check balancing what had already been established over in England. And he's referencing to what was a part of their established government back then that we had adopted over here. It's the same way with the church society. In most churches that are set up as a authentic grand church, it's not just the minister or the preacher that's in charge, but it's the deacon body up underneath the preacher or the minister. And what I'm talking about now is church procedures. I'm talking about what goes on in the spiritual world that's set up legitimately, regardless whether it's Baptist, Presbyterian, Church of Christ, Methodist, Pentecostal, Baptist, even Jehovah's Witness, and etc. They are under an established set of rules. And the reason why is because if there is a problem with the primary minister, the preacher, the messenger per se, they can do like they done in the Assembly of God Association whenever it come to Jimmy Swaggart towards banning him towards being able to preach for a solid year is what they recommended, to go through severe marriage counseling because of what had happened in his public domain. We see from experience that Jimmy Swaggart broke away from the Assembly of God Association to where he was no longer ruled by the Assembly of God Association and just picked up an independent ministry based around Jimmy Swaggart's ministry. In other words, he had privatized himself in that degree. That way, he could basically set up his own set of rules in the regard towards being like a king. That's what happened to Jimmy Swaggart's ministry. Jimmy Swaggart repented. Jimmy Swaggart got back in the eyes of society. And today, Jimmy Swaggart's ministry is bigger, probably, than what it's ever been in regard to meeting people in foreign countries in foreign affairs. But, the way that I understand it, Jimmy Swaggart's ministry is still set up, even though it is an independent ministry or a private ministry. It is still set up with a council, a deacon body up underneath him, to where if he flubs up again, he will have certain people that will nanny boo boo him to the effect that, hey, you're still not within the guidelines of the church committee. And because you're not within the guidelines of the church committee, we're going to ask you to step down. That's the way the church arena, the church society, the church community is supposed to operate. You're not supposed to have, per se, a king that rules over all the churches. The only king that we have that rules over us is the King of the Lord Jesus Christ of Nazareth, supernaturally, spiritually speaking. Each independent church is supposed to operate under the same guidelines as that church, if they are a true, authentic Christian gospel church. The same way with this government. This government is not ruled under one particular person. That's what this guy is talking about. Let's listen to it and back it up. That way we'll understand it.
A people who had overthrown...
Back it up. Stop there.
...and entitled to do no wrong.
Listen to this.
In our Declaration of Independence, the framers set forth...
In our Declaration and Independence. In our Declaration and Independence. The United States of America. Listen to this.
A series of impeachable offenses that the king had committed against the American colonists. When the framers later convened in Philadelphia to draft our Constitution, they were united around a simple, indisputable principle that was a major safeguard for the public. We, the people, against tyranny of any kind. A people who had overthrown a king were not going to turn around just after securing their independence from corrupt monarchical tyranny and create an office that, like the king, was above the law and could do no wrong.
There you go. In other words, they're not going to discard one to create another.
The framers created a chief executive to bring energy to the administration of federal laws, but to be accountable to Congress for treason, bribery, or other high crimes and misdemeanors. The framers' concern about the need to protect against a corrupt president was evident throughout the convention. And here, I must thank my prior two friends who have spoken and referred to a North Carolinian, William Davey. I will refer to another North Carolinian in the Constitutional Convention, James Iredell, whom President Washington later appointed to the Supreme Court, assured his fellow delegates the president, quote, is of a very different nature from a monarch. He is to be personally responsible for any abuse of the great trust placed in him, unquote. This brings us, of course, to the crucial question we're here to talk about today, the standard for impeachment. The Constitution defines treason, and the term bribery basically means using office for personal gain, or I should say misusing office for personal gain. And as Professor Feldman pointed out, these terms derive from the British, who understood the class of cases that would be impeachable to refer to political crimes, which included great offenses against the United States, attempts to subvert the Constitution, when the president deviates from his duty, or dares to abuse the power invested in him by the people, breaches of the public trust, and serious injuries to the Republic. In his influential essay in the Federalist Papers, Alexander Hamilton declared that impeachable offenses are those offenses which proceed from the misconduct of public men, or in other words, the abuse or violation of some public trust, and relate chiefly to injuries done immediately to the society itself. Several themes emerge from the framers' discussion of the scope of impeachable offenses and impeachment practice. We know that not all impeachable offenses are criminal, and we know that not all felonies are impeachable offenses. We know further that what matters in determining whether particular misconduct constitutes a high crime and misdemeanor is ultimately the context and the gravity of the misconduct in question. After reviewing the evidence that's been made public, I cannot help but conclude that this president has attacked each of the Constitution's safeguards against establishing a monarchy in this country. Both the context and gravity of the president's misconduct are clear. The favor he requested from Ukraine's president was to receive, in exchange for his use of presidential power, Ukraine's announcement of a criminal investigation of a political rival. The investigation was not the important action for the president. The announcement was, because it could then be used in this country to manipulate the public into casting aside the president's political rival because of concerns about his corruption. The gravity of the president's misconduct is apparent when we compare it to the misconduct of the one president who resigned from office to avoid impeachment, conviction, and removal. The House Judiciary Committee in 1974 approved 3 articles of impeachment against Richard Nixon, who resigned a few days later. The first article charged him with obstruction of justice. If you read the Mueller report, it identifies a number of facts, I won't lay them out here right now, that suggest the president himself has obstructed justice. If we look at the second article of impeachment approved against Richard Nixon, it charged him with abuse of power for ordering the heads of the FBI, IRS, and CIA to harass his political enemies. In the present circumstance, the president is engaged in a pattern of abusing the trust placed in him by the American people by soliciting foreign countries, including China, Russia, and Ukraine, to investigate his political opponents and interfere on his behalf in elections in which he is a candidate. The third article approved against President Nixon charged that he had failed to comply with 4 legislative subpoenas. In the present circumstance, the president has refused to comply with and directed at least 10 others in his administration not to comply with lawful congressional subpoenas, including Secretary of State Mike Pompeo, Energy Secretary Rick Perry, and Acting Chief of Staff and Head of the Office of Management and Budget, Mick Mulvaney. As Senator Lindsey Graham, now chair of the Senate Judiciary Committee, said when he was a member of the House on the verge of impeaching President Clinton, the day Richard Nixon failed to answer that subpoena is the day he was subject to impeachment because he took the power from Congress, over the impeachment process away from Congress, and he became the judge and jury. That is a perfectly good articulation of why obstruction of Congress is impeachable. The president's defiance of Congress is all the more troubling due to the rationale he claims for his obstruction. His arguments and those of his subordinates, including his White House counsel, in his October 8th letter to the Speaker and 3 committee chairs, boils down to the assertion that he is above the law. I won't reread that letter here, but I do want to disagree with the characterization in the letter of these proceedings, since the Constitution expressly says, and the Supreme Court has unanimously affirmed, that the House has the sole power of impeachment, and like the Senate, the House has the power to determine the rules for its proceedings. The president and his subordinates have argued further that the president is entitled to absolute immunity from criminal procedure, even an investigation for any criminal wrongdoing, including shooting someone on Fifth Avenue. The president has claimed further he's entitled to an absolute executive privilege, not to share any information he doesn't want to share with another branch. He's also claimed the entitlement to be able to order the executive branch, as he's done, not to cooperate with this body when it conducts an investigation of the president. If left unchecked, the president will likely continue his pattern of soliciting foreign interference on behalf of the next election, and of course, his obstruction of Congress.
A runaway train.
The fact that we can easily transpose the articles of impeachment against President Nixon onto the actions of this president speaks volumes. And that does not even include the most serious national security concerns and election interference concerns at the heart of this president's misconduct. No misconduct is more antithetical to our democracy, and nothing injures the American people more than a president who uses his power to weaken their authority under the Constitution, as well as the authority of the Constitution itself. May I read one more sentence, or I'm sorry.
The witness may have another sentence or two.
Thank you. If Congress fails to impeach here, then the impeachment process has lost all meaning. And along with that, our Constitution's carefully crafted safeguards against the establishment of a king on American soil. And therefore, I stand with the Constitution, and I stand with the framers who were committed to ensure that no one is above the law.
Thank you, Professor. Professor Turley.
Thank you, Chairman Nadler, Ranking Member Collins, members of the Judiciary Committee. It's an honor to appear before you today to discuss one of the most consequential functions you were given by the framers, and that is the impeachment of a president of the United States. 21 years ago, I sat before you, Chairman Nadler, and this committee to testify at the impeachment of President William Jefferson Clinton. I never thought that I would have to appear a second time to address the same question with regard to another sitting president. Yet here we are. The elements are strikingly similar. The intense rancor and rage of the public debate is the same. It's the atmosphere that the framers anticipated. The stifling intolerance of opposing views is the same. I'd like to start, therefore, perhaps incongruously, by stating an irrelevant fact. I'm not a supporter of President Trump. I voted against him. My personal views of President Trump are as irrelevant to my impeachment testimony as they should be to your impeachment vote. President Trump will not be our last president, and what we leave in the wake of this scandal will shape our democracy for generations to come. I'm concerned about lowering impeachment standards to fit a paucity of evidence and an abundance of anger. I believe this impeachment not only fails to satisfy the standard of past impeachments, but would create a dangerous precedent for future impeachments. My testimony lays out the history of impeachment from early English cases to colonial cases to the present day. The early impeachments were raw political exercises using fluid definitions of criminal and non-criminal acts. When the framers met in Philadelphia, they were quite familiar with impeachment and its abuses, including the Hastings case, which was discussed in the convention, a case that was still pending for trial in England. Unlike the English impeachments, the American model was more limited, not only in its application to judicial and executive officials, but its grounds. The framers rejected a proposal to add maladministration because Madison objected that so vague a term would be equivalent to a tenure during the pleasure of the Senate. In the end, various standards that had been used in the past were rejected. Corruption, obtaining office by improper means, betraying the trust of a foreign power, negligence, perfidy, peculation, and oppression. Perfidy or lying and peculation, self-dealing, are particularly relevant to our current controversy. My testimony explores the impeachment cases of Nixon, Johnson, and Clinton. The closest of these three cases is to the 1868 impeachment of Andrew Johnson. It is not a model or an association that this committee should relish. In that case, a group of opponents of the president, called the Radical Republicans, created a trapdoor crime in order to impeach the president. They even defined it as a high misdemeanor. There was another shared aspect besides the atmosphere of that impeachment and also the unconventional style of the two presidents. And that shared element is speed. This impeachment would rival the Johnson impeachment as the shortest in history, depending on how one counts the relevant days. Now, there are three distinctions when you look at these, or three commonalities when you look at these past cases. All involved established crimes. This would be the first impeachment in history where there would be considerable debate, and in my view, not compelling evidence of the commission of a crime. Second is the abbreviated period of this investigation, which is problematic and puzzling. This is a facially incomplete and inadequate record in order to impeach a president. Allow me to be candid in my closing remarks because we have limited time. We are living in the very period described by Alexander Hamilton, a period of agitated passions. I get it. You're mad. The president's mad. My Republican friends are mad. My Democratic friends are mad. My wife is mad. My kids are mad. Even my dog seems mad. And Luna's a golden doodle, and they don't get mad. So we're all mad. Where has that taken us? Will a slipshod impeachment make us less mad? Will it only invite an invitation for the madness to follow every future administration? That is why this is wrong. It's not wrong because President Trump is right. His call was anything but perfect. It's not wrong because the House has no legitimate reason to investigate the Ukrainian controversy. It's not wrong because we're in an election year. There is no good time for an impeachment. No, it's wrong because this is not how you impeach an American president. This case is not a case of the unknowable. It's a case of the peripheral. We have a record of conflicts, defenses that have not been fully considered, unsubpoenaed witness with material evidence. To impeach a president on this record would expose every future president to the same type of inchoate impeachment. Principle often takes us to a place we would prefer not to be. That was the place 7 Republicans found themselves in the Johnson trial, when they saved a president from acquittal that they despised. For generations, they've been celebrated as profiles of courage. Senator Edmund Ross said it was like looking down into his open grave. And then he jumped because he didn't have any alternative. It's easy to celebrate those people from the distance of time and circumstance. In an age of rage, it's appealing to listen to those saying, forget the definitions of crimes, just do it. Like this is some impulse buy Nike sneaker. You can certainly do that. You can declare the definitions of crimes alleged are immaterial and just an exercise of politics, not the law. However, those legal definitions and standards, which I've addressed in my testimony, are the very thing that divide rage from reason. This all brings up to me, and I will conclude with this, of a scene from A Man for All Seasons with Sir Thomas More, when his son-in-law, William Roper, suggested that More was putting the law ahead of morality. He said More would give the devil the benefit of the law. When More asks Roper, would he instead cut a great road through the law to get after the devil? Roper proudly declares, yes. I'd cut down every law of England to do that. More responds, and when the last law is cut down and the devil turned around on you, where would you hide, Roper? All the laws being flat. He said, this country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? And he finished by saying, yes, I'd give the devil the benefit of the law for my own sake. So I will conclude with this. Both sides of this controversy have demonized the other to justify any measure in their defense, much like Roper. Perhaps that's the saddest part of all of this. We have forgotten the common article of faith that binds each of us to each other in our Constitution. However, before we cut down the trees so carefully planted by the framers, I hope you will consider what you will do when the wind blows again, perhaps for a Democratic president. Where will you stand then when all the laws being flat? Thank you again for the honor of testifying today, and I'd be happy to answer any questions.
I want to weigh in real quick. This will end this particular part one sequence of this particular hearing today, which is December the 4th, 2019. Jesus talked about the law quite a few times. Matter of fact, Jesus said that he did not come to abolish or do away with the law, but rather than to fulfill the law. And in perspective of what he was talking about that I have interpreted, is that he was talking about the law of grace. The law of grace that was to be given to all of mankind, of having a channel to be able to go to the Father, because now the Son sits upon the right hand of the Father that makes intercession prayer for us, that if we sin, we have an advocate with the Father who maketh intercession prayer for us based around the fulfillment of the law. The fulfillment of the law. Not a new law, but the fulfillment of the law. The law that goes all the way back to the law of Abraham, the law of Isaac, the law of Jacob, the law going all the way back to whenever God redeemed the planet through Noah and his family. As I spoke of earlier a while ago, pertaining to Jimmy Swaggart's ministry, it was established based upon the principles of that very law through the Assembly of God Association, which is somewhere up in Missouri. I think Springfield, Missouri, but I may be wrong about that, but I think it's Springfield, Missouri. When the law enforcer in the spiritual law, in the spiritual laws, had made a mockery out of God's law, was whenever that committee, that organization called the Assembly of God Association, stepped up immediately. They didn't debate it. They didn't prolong it. They didn't vote on it. They called him to the red carpet. In other words, they put Jimmy Swaggart on the plank immediately, and then it was up to the administration to save itself, because they realized that the messenger that was bringing forth the message had become corrupt, or was not sincere in practicing what he preached. And rather than make a mockery out of the whole association made a mockery out of Jimmy Swaggart and said, there he is. And they basically handed him over to the wolves. And the wolves here in America got to gnawing and pawing and chewing on him in one direction or the other, pertaining to the news media and the news articles that was being put out about Jimmy Swaggart. And I don't want people to think that I'm trying to pick on Jimmy Swaggart's ministry, because I'm not. I'm just using this as an open illustration so that we can understand what's happening here pertaining to our political law. Now keep in mind before you get too excited here, whenever you listen to this, providing that you do hear it, there's many laws. There's thousands, if not millions, if not billions of laws throughout the proceedings of each and every country. Because one country's laws may not be the same as the other country's laws. There's laws in I think it's Taiwan, to where if you're caught chewing bubble gum, it's an automatic $500 fine. And there's other laws in other countries that you can marry a teenage girl as young as 12 or 13 years old. As long as you are a citizen of that country, you abide by that country's laws. We ourselves has went through the involvement of various laws. We had the Red Man's Law that was converted by the colonizing through the Europeans of coming over here and forming our American laws. Our American laws had to eventually restrain or go up against the king's laws pertaining to the King of England. King George III, I believe it was. We established our own laws back before and during the Civil War era. And of course, after the Civil War era, we evolved even further towards committees and agencies that was now being divided state for state, state for state. And to this day, each state has its own bylaws and laws pertaining to the do's and the don'ts towards what it either can or what's acceptable and what isn't acceptable based upon the people, the will of the people, and based upon a lot of times the genetics of where they are. In other words, if you're in Florida, it's okay to put down pipes within 3 or 4 inches below the ground or 6 inches below the ground. To where if you're up in Minnesota somewhere, it's by law, you're supposed to go at least 2 foot deep. You know, there's different laws for different reasons. Our laws here in America have evolved. And since World War I, we have evolved into the status of flow of no longer being able to openly announce someone's death based around 2 or 3 people or one particular person and do a public execution pertaining to hangings. Since World War I, we have become more modernized. We have become more civilized in the aspect in our laws. As the gentleman was talking there, and I'm going to reverse it one more time so you can listen to it again in his ending statement. it is only whenever someone such as Donald Trump, which once more, he's devoting his life around political laws. I'm devoting my life around spiritual laws. But even though I'm devoting my life around spiritual laws, I still have to tiptoe around pertaining to political laws. And of course, I have already made my case in describing the fact that in the results of my political rights pertaining to these political laws, my rights have been violated since the beginning phases of this ministry, going all the way back to 1989, whenever the first sword symbolizing peace on earth was confiscated by the Madison County judicial system in Tennessee. Madison County, down in Jackson, Tennessee, confiscated from the ministry. That was a violation of the spiritual as well as the political laws established here in the United States, based around my Constitution. Freedom of speech, freedom of religion, the freedom to bear arms, and it didn't matter if it was arms pertaining to firearms, or the arms pertaining to bow and arrow, or the arms pertaining to a sword, or a BB gun, or a slingshot. According to the laws of the land, I'm supposed to have that right if I desire to want to have some sort of a arm. And it doesn't have to be a firearm. Right to bear arms. You have a right to bear arms. Why do you have a right to bear arms? You have a right to bear arms to protect yourself in case of an aggressor, in case of somebody that wants to do bodily harm to you. I have made the point, and I'll make the point again as I'm ending in my final comments in this segment 1 here. It wasn't that the founder of the Windmill Ministries failed the church society in the church society not supporting or backing the founder of the Windmill Ministries missions. It was the other way around. It was the fact that none of the general public pertaining to the spiritual political advisors or the spiritual pillars of the community never wanted to support the founder of the Windmill Ministries. And because they did not support the Windmill Ministries, I don't know, maybe they thought that the story was too unbelievable to them. Or maybe the fact that they was just ignorantly taught to the point that they was ignorant of biblical Bible prophecy of how Jesus was teaching of the oncoming end time events was going to occur based around, I'm going to repeat it one more time, based around when you shall see the abomination of desolation spoken of by Daniel the prophet. Know that the end is near. Know that we are at the doors. I don't know if they just was unintentionally taught incorrectly, or if they purposely wanted to go through life blinded and ignorant and deceived. But one or the other had to obviously happen to the degree that they either thought that I was lying towards being a heretic, or they themselves was fighting up against the very will of God. Whether or not it was intentional or not intentional, this is one of the reasons why I believe that has put us where we are today, December the 4th, 2019 here in America. Nobody wanted to believe my story. Nobody wanted to accept my story as it being the truth, the gospel. Nobody wanted to put credibility in my story, because I think of what began over in Kenton, Tennessee in 1983, whenever they first made the first initial blow in my life towards trying to stick me off into some sort of a psychiatric ward, towards saying that I was crazy, based around the fact that I was talking about these very things that I'm talking about right now in regard to end-time biblical Bible prophecy pertaining to the Antichrist, the two witnesses, the mark of the beast, the devil, the false prophet, the Antichrist, based around the seven churches, based around the seven the seven seals, based around the seven trumpets. Obviously, I was dealing with people that did not have the type of wisdom or knowledge that I had, and because of it, rather than try to take time to understand where I was coming from, it was much easier for them to demonize me and to kick me off to the curb and say, he's crazy. He's a lunatic. And he needs to be put into the bushel or barrel with the rest of the lunatics, with the rest of the crazies. They was either doing that or they was trying to put me into the category by compartmentalizing me by saying that I was some sort of a fraudulent manipulator. Like I was trying to hustle the people, even though I've never asked them for a single red cent. Even to this day, December the 4th, 2019, I have yet to ask Alamo Baptist Church for a single red dime, or any of the other local churches around here. A matter of fact, I have offered to give them money and have given them money in the past. Not only the Baptist Association, but also the Assembly of God Association, also the Church of God Association. I've given money to other associations in the past, regardless whether it was Red Cross or supporting children's or St. Jude's or whatever. Giving money. Giving them wisdom. Giving them knowledge. Giving them hope. Giving them my story. And to this day, still hadn't gotten back not one red cent. Hadn't even gotten back a thank you towards Juby. We appreciate you. Thank you for you stepping out in not only a patriotic form, but as being a spiritual liberator towards explaining this all to us. I have never run upon such of a demonic, sorcery type environment that was that much against seeing biblical Bible prophecy fulfilled. That the seed or the egg that got planted during Ronald Reagan's administration. Let's back up once more. This will end this particular sequence. I don't know yet how I'm going to label this towards these opening statements, but I felt like that these opening statements was going to be a schooling in regard to our democracy, and not just our democracy, but any true democracy that wants to do the right thing for the right purpose, for the people, for the benefit of the people, not just the benefit of one particular person or one particular group or one particular entity to satisfy their needs. Let's back this up real quick, and then we'll go from there.
I thank the witnesses.
Let's back up. In his ending statement, I think it's along
to each other in our Constitution. However, before we cut down the tree so carefully planted by the framers, I hope you will consider what you will do when the wind blows again, perhaps for a Democratic president. Where will you stand then when all the laws being flat? Thank you again for the honor of testifying today, and I'd be happy to answer any questions.
I didn't go back far enough.
I thank the witness.
Sorry.
celebrate those people from the distance of time and circumstance. In an age of rage, it's appealing to listen to those saying, forget the definitions of crimes, just do it. Like this is some impulse buy Nike sneaker. You can certainly do that. You can declare the definitions of crimes alleged are immaterial and just an exercise of politics, not the law. However, those legal definitions and standards, which I've addressed in my testimony, are the very thing that divide rage from reason. This all brings up to me, and I will conclude with this, of a scene from A Man for All Seasons with Sir Thomas More, when his son-in-law, William Roper, suggested that More was putting the law ahead of morality. He said More would give the devil the benefit of the law. When More asks Roper, would he instead cut a great road through the law to get after the devil? Roper proudly declares, yes. I'd cut down every law of England to do that.
I want to stop right there. I'd cut down every law to do that. That was the assumption that I had about the United States government in their laws, in our laws, pertaining to ever even going to war against the aggressiveness that was happening over in the Middle East pertaining to Saddam Hussein, was to go up against the axis of evil and to try to bring stability to that region. That was what I was taught and how that I had interpreted the law. The law of our land was to drive out this type of barbaric, heathenistic, cruel, insensitive behavior. That was the only reason why that I felt like that God had called me into this spiritual arena and ordained me or selected me to do what the founder of the Windmill Ministries was devoted in doing, was to go up against Satan, go up against the features of Satan, go up against the teachings of Satan, go up against the evil empire that had been formulated by Satan. And instead of Dennis Jackson, the individual that's talking to you right now, Dennis James Juby Jackson, instead of him being rewarded by society over here in America, he got punished. He got punished. Just like David and I being overly concerned. Or to us it wasn't overly concerned. To them it was overly concerned, I guess. But we was concerned about the welfare and the benefit of 3 innocent children across the road who was being exposed to unparalleled behavior that was going on that went beyond the rims of normal. When you have people that's kicking down the door off of the hinges of a trailer and jumping up and down on top of their car like a bunch of baboons. When the ambulance has done been called out here twice because the girl had taken on some sort of a beating from her boyfriend, but yet now whenever the ambulance pulls up here, well, how does she respond? Oh, I fell. You didn't fall. Your boyfriend got too aggressive with you. The next thing you know, he cracked a couple of your ribs. Pertaining to a love-hate relationship that was happening. In the meantime, the 3 children over there was being exposed to that on a day-to-day level. And once more, instead of the founder of the Windmill Ministries being rewarded by the judicial system towards doing their jobs, their civil duties, pertaining to the Good Samaritan laws, they flipped it. And the next thing you know, I was the one that was being charged. And I was the one that got caught in between the catch-22 to the point that now they had captured me and put me just exactly where they wanted me to be all along to begin with, which was in jail. They had imprisoned me for trying to do the fair and just and right thing. Not only did they imprison me, but they put such of a high bond upon me that there was basically no way for me to get out. And I could have fought the system. Instead of fighting it for 37 days, I could have fought the system for 137 days or 237 days. But ultimately, the end results was still going to be the same. Because they had outpowered me. They had outmaneuvered me. They had outsmarted me, especially due to the fact that they was attacking me in my most vulnerable position towards just recently losing a loved one, my brother. Talk about being hit below the belt. Oh, trust me, this ministry has been hit below the belt in more times than one because of an evil, demonic, deranged society that has now escalated its bill up to $23 trillion and over 2.3 incarcerated federal, state, and local prisoners.
Moore responds, and when the last laws cut down and the devil turned around on you, where would you hide, Roper? All the laws being flat. He said, this country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then?
I do. And though I may not stand upright in this lifetime pertaining to the laws that have been cut down, I know that I will stand upright in the lifetime to come pertaining to God's holy law, because God's holy law is going to be the ultimate law that's going to stand above and beyond not just the laws here in America, but the laws throughout the world that are probably billions, if not millions, at least millions, but possibly billions of laws. It will be God's law that will ultimately stand, and in behind His law is where I'll stand, would be the answer that I would give.
And he finished by saying, yes, I'd give the devil the benefit of the law for my own sake. So I will conclude with this.
I don't give the devil nothing.
Both sides of this controversy have demonized the other to justify any measure in their defense, much like Roper. Perhaps that's the saddest part of all of this. We have forgotten the common article of faith that binds each of us to each other in our...
But you can't play games with the devil. You don't give the devil nothing. The devil don't deserve the right of a law. That's why you don't give the devil no law. You don't give the devil no right to no law.
Constitution. However, before we cut down the trees so carefully planted by the framers, I hope you will consider what you will do when the wind blows again, perhaps for a Democratic president. Where will you stand then when all the laws being flat? Thank you again for the honor of testifying today, and I'd be happy to answer any questions.
I thank the witnesses.
Mr. Chairman, I seek recognition.
Who seeks recognition?
Me, Mr. Chairman.
For what purpose does the gentleman seek recognition?
Mr. Chairman, I have a motion pursuant to Rule 11, specifically 2K6. I move to subpoena the individual commonly referred to as the whistleblower. I asked to do this in
The
executive
gentleman has stated
session.
his motion. Do I hear a motion to table?
I move to table the motion.
Motion is to table. All in favor say aye. Aye. Opposed, no?
Mr. Chairman, roll call vote.
Motion to table is approved. The roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye, Ms. Lofgren.
Aye.
Ms. Lofgren votes aye, Ms. Jackson Lee.
We're going to back up.
Mr. Chairman.
This will end part one on the last hearings. I called them the nanny boo-boo hearings. I may just call these the boo-boo hearings. The boo-boo hearings in the White House crisis. I don't know yet for sure how I'll label this. But this will end part one. This is a sad day. A sad day for history. A sad day for the American founders. A sad day for the American people. This is a sad day. And it needs to be resolved as quickly as possible so that we, the people, can move on to other affairs. Regardless whether it's domestic or foreign. Because all this does is bog down the system to the point that our people that we have hired to put in these positions are no longer doing the jobs that we put them in there to do. And that, above all this, is what's really sad, because we're not getting the bang for the buck pertaining to why that we ever allowed for our taxes to be taken out of our incomes so that it would afford to be able to pay for people's salaries like this. That's the sad part. Thanks again.